Doherty, Chair of the Government Operations Committee. Today is Tuesday, September the 17th, and we are here today to discuss Docket 1264, message and order approving a home rule petition to the General Court entitled An Act Authorizing the Boston Redevelopment Authority to Grant Easements for Utility Purposes over a portion of a certain parcel of land located in the City of Boston. The matter was sponsored by Mayor Martin J. Walsh, referred to the committee on September the 11th of 2017. As stated in the transmittal from Mayor Walsh, this home rule petition seeks to allow existing property owners and their tenants to update the utility infrastructure on the property and to continue its current use along the Long Wharf. The home rule petition specifies electric and cable companies, specifically NSTAR, Verizon, and Comcast, who would have to enter into a contract with the Boston Redevelopment Authority in relation to this easement. This hearing is being streamlined on Boston City Council TV online, along with being recorded and broadcast on Comcast Channel 8, RCN 82, and Verizon 1964. I'm joined here by my colleagues, District City Councilor Lydia Edwards, and my colleague from District 3, City Councilor Frank Baker. And joining us as part of the panel, we have Rich McGinnis, Deputy Director for Climate Change and Environmental Planning, as part of the Boston Redevelopment Authority, doing business as the Boston Planning and Development Agency, as well as Larry DeCara, attorney for the Parcel. And what I would like to do, gentlemen, is if we can go directly to public testimony. Let's hear from the residents, from the neighbors, and other interested parties, and then you can listen to their concerns, and then maybe in your presentation address some of those issues, as this is sort of the first step in, I think, a number of things that need to take place between now and passage. So with that, I'm going to ask, I get Victor Bronya is here from NURA, and he'll be followed by Angela Holm, who will be followed by, I think, is Ann Rogan. Did I see Ann? Where is Ann? Ann. Oh, Ann, there's Ann. Followed by Ann Rogan, and followed by Joshua, looks like Sydney, who'll be followed by Mary McGee, who'll be followed by Thomas Schiavone. And then if there's any additional public testimony other than that, we'll shift to the panel. And then if we have additional folks indicating a desire to speak publicly, we'll address them. So with that, Victor, it's good to see you. Welcome back to the City Council.
Good afternoon.
Name and affiliation, and you have the floor. Tell us what's on your mind.
Thank you for inviting me. And although my affiliation is NURA, I must say that this has not been presented to NURA, and I don't represent them for a vote. But so my comments are my personal comments, and they are procedural because I cannot address substantively what is being requested because I have seen no plans, I've seen no details, I don't know whether the easements will be permanent or temporary and so forth. Procedurally, I have distributed to all the members of the committee a letter from the National Park Service to the state, a copy of the letter, dated June 20, 2014, and the letter on page 2 refers to events in 1983. In 1983, the MBTA Blue Line needed access from Long Wharf, and the access was granted but through easements given to the MBTA, but it was acknowledged by the BRA in 1983 that National Park Service approval had to be given. And that brings us to the two lawsuits that were involved in Long Wharf and the National Park Service and the BRA. I will just quickly skim over them because I'm sure that you all know about them, that 10 or 12 years ago, the BRA decided they wanted to put a restaurant at the end of Long Wharf. 10 North End residents said that is not what ought to be done at the end of Long Wharf. I'm reminded when I go into the Boston Public Library, free to all, the Boston Public Library's motto. That was pretty much what motivated us in 10 years ago. 10 of us brought a lawsuit which, when in the state court, when it was clear that the judge was leaning in our direction and away from the BRA brought a lawsuit in the federal court, Federal District Court of Massachusetts, against the National Park Service. that lawsuit was decided in favor of the National Park Service against the BRA. That was appealed. So that brings me here today to say that what was applicable in 1983 continues to be applicable now. That is that National Park Service approval is required. And I'd like to conclude with just reading the conclusion of the decision in the Federal Appeals Court, which is, although we need go no further, we think an additional comment is in order. The BRA complains that by upholding National Park Service's decision, we will be allowing the agency to, quote, restrict the entirety of an invaluable piece of the Boston waterfront in perpetuity, end quote. This complaint is groundless. As we have already explained, the limitation of the pavilion area, but the limitation applies throughout to the entirety of Long Wharf. That is the portion that's owned by the BRA. As we have explained, the limitation of the pavilion area to public outdoor recreational use is exactly what the BRA offered when it applied for and received over $750,000 in federal financial assistance. For now, at least, the long war over Long Wharf is at an end. Based on the reasoning elaborated above, the judgment of the district court is affirmed. So, after a long war over Long Wharf, we now stand where we were in 1983. That is, that the National Park Service must be contacted. They must give their approval, disapproval, or whatever they want to give. And I would suggest, therefore, procedurally, that no action be taken on this home rule petition until the National Park Service has spoken. Thank you.
Thank you, Victor. Angela Holm. Welcome, Angela, if you can state your name and affiliation for the record.
Good afternoon, councilors. My name is Angela Holm. I'm the Director of Government and Regulatory Affairs for Comcast. Here today to provide remarks and testimony regarding the proposed legislative act that would allow for an easement agreement. I could say that we are not opposed to the passage of this act. We look forward to a time when we can provide services to this parcel, and we have no problems with either Section 1 or Section 2 of the legislation as proposed. Where we do have material concerns at this time is in Sections 3 and Section 4. Specifically for Section 3, I would like to stress our material concerns with the compensation methods provided for in the proposed easement legislation, specifically that the compensation method is referred to as a condition of the easement rather than establishing a means of fair negotiations or proportionate costs. So I just want to put that on the record. Again, Comcast maintains its interest in servicing this parcel. We do not oppose the passage of this act, but we would like to see Section 3's language reworked to make it more economically feasible for Comcast to provide our services. Regarding Section 4, we would just move to strike certain language from Section 4 as we don't see it necessary or productive to hold full liability for the entire parcel, rather just the portion of the land to which we would use. So I would just ask that we strike the language control of and liability and responsibility for, specifically.
Angela, can you, because we have 3 sections, can you, how long is Section 4? Is it just a couple sentences? Can you read Section 4?
Sure, I have it with me. Section 4, notwithstanding any general or special law to the contrary, on the effective date of this act, the Boston Redevelopment Authority may grant a temporary license not to exceed 5 years at a nominal amount to NSTAR Electric Company, Comcast, and Verizon New England, Inc. in order to provide NSTAR Electric Company, Comcast, and Verizon New England, Inc. with immediate and complete access to, and here's the portion that we have a concern with, control of and liability and responsibility for the property described in Section 2 for the purposes of this act until the conveyances authorized by this act take effect.
Thank you, Angela. And Rich, can we get a full copy of the, we have the home rule petition from the mayor. There's the 3 sections. It's missing the 4th. How many more sections? Is it just 4 sections?
Yeah, we received a revised copy of the act, I think it was earlier this week or last week, with a Section 4 added to it.
Do you have a copy, Rich, a full copy of it? So could Michelle make some copies for the council? Or, okay.
Our primary concern remains Section 3 and the way that methodology is worked out for compensation. We want this to be feasible for us. We want to be able to provide our services to the parcel, but not the way it's written as it is now. I'd also like to point out for the record that the correct legal name for Comcast in this context, both for the legislation and for the easement agreement itself, should be Comcast of Boston, Inc., organized under the laws of New York.
Okay. Very good.
Thank you
For your testimony, Angela. Ian Rogan, would you like to come down at this time and offer testimony, or you'll defer to Larry? Okay. Joshua Sidney, same thing. Joshua will defer. Mary McGee. Mary's a North End resident. Welcome, Mary. Mary, could you state her name and affiliation, if any, and you have the floor. Welcome.
Sorry to be slow.
No worries.
Hopefully
We
my
have plenty of time
silver
for
hair
you.
will excuse me. Honorable Chairman and the other city councilors, my name is Mary McGee. I am a longtime resident of the North End. To state the obvious, Long Wharf is a wonderful resource for the residents of Boston, and because of its proximity to the North End residents feel a particular sense of stewardship toward the site. This is a proposal to take something which is set aside for the benefit of the public and give it over in some way to a private use. It may be totally unobjectionable. We just don't know because there's been no public process. We found out about the hearing over the weekend, and it was just announced on Friday. The petition references documents and a plan. We haven't seen the documents, we haven't seen the plan, and now I'm finding out we actually haven't even seen the whole petition. And so we don't know what's there at present, why what's there at present isn't adequate. There may be good answers to all of these things, but we just don't know. And so I think all that I'm asking for today is that the neighborhood process be followed. For NURA, which is the organization I belong to, it's a pretty simple process. We have a zoning and licensing committee. It's very easy to get on the agenda of that committee. There's a meeting once a month, and then within a week or two after that, the matter comes before our monthly meeting. So we're not asking for any particular delay, just that we have a chance to find out what this is all about, where this is a site of such historic importance to all the residents of the city. Thank you.
Thank you very much, Mary. Thomas Schiavone. Thomas, welcome.
I'm Thomas Schiavone, and I'm a North End resident. I want to just reaffirm the need for a thoughtful review. Mr. Brunya has talked about the fact that the National Park Service has not spoken. Ms. McGee has pointed out that the Neighborhood Residents Association has not had an opportunity to review. And we respect this process of representative democracy. Our immediate councilor from our district and in the at-large and the others who care about our city. And the only thing that we ask is participatory democracy, and we're not seeking to delay this, but just give us an opportunity to participate in the process, and then you will have the final ability to determine whether or not it's in the public interest. Thank you.
Very good. Thank you, Thomas. So I'll throw it right over to Rich McGinnis from the BPDA to get started, and then obviously Larry on behalf of the proponents. So welcome, and state your name and affiliation as well.
I'm Richard McGinnis, Deputy Director for Climate Change and Environmental Planning from the Boston Planning and Development Agency. The Boston Planning and Development Agency owns and manages Long Wharf, a historic property along our downtown waterfront. Planned and operated as a mix of commercial, water-dependent, and open space uses. We support the legislation to allow subsurface easements for our tenants and abutters within the property, protected pursuant to Article 97 of the Commonwealth's Constitution. We understand this legislation is needed based upon the feedback we received from the state's, the Commonwealth's Division of Conservation Services. We don't disagree with the observations of protected open space out there. We flagged this when these easements were requested to us. We reached out to the Commonwealth that oversees Article 97 protected open space, but they're also the kind of local representative of the National Park Service. And they explained to us that National Park Service, there isn't an issue with the National Park Service layer of protection for subsurface utilities. It's more of an Article 97 issue. So it's a state, protected open space. And that typically those are modified through legislation to allow these easements. If you look at Long Wharf, there's a web of easements that already exist, including Eversource and other utilities, Boston Water and Sewer, MWRA, that were pre-existing and are maintained from time to time. So we did reach out to the state. They don't believe it's a National Park Service issue. It's more of a state issue. They state that you can put subsurface utility lines underneath protected open space, provided that they are granted legislative relief, and that's why the legislation was put forward. We agree. We're happy to do some outreach with NURA and others to let them know about our protocol. We're approached by either our tenants or property owners to do work within our right-of-way. Those are reviewed by our capital construction people. If there are any above-ground disturbances or structures, those are reviewed by urban design staff to make sure they're consistent with the property being disturbed. So we do have an internal process in place and are happy to do whatever outreach, certainly to NURA, the Wharf District Council, who are great kind of shepherds of the downtown waterfront. We don't believe these utility easements will cause any harm to the public way. The surface will have to be restored to its original condition. But these utilities also support the businesses that are out there, including Boston Harbor Cruises. We're looking to expand Gateway to Boston Harbor Islands. There's a marina. So it's not just the commercial properties, but also the water-dependent properties that are out there. We require a fee for any property that's licensed by us. So we'd expect the same for any utilities using BPDA property for private purposes. We support Section 3. This is distinct from a city roadway. This is BPDA-owned property, and any type of easement or license agreement requires a fee to us for our care and maintenance of our properties. Thank you.
And welcome back to the chamber, Larry.
Great, thank you very much. For the record, Lawrence Takara, 10 Post Office Square. And I represent Capital Properties, the owner of record of the Trout House and the Custom House block. These two buildings have been on Long Wharf for a long time. The Trout House precedes the creation of the city of Boston, and we believe dates back approximately 275 years. It was used as a counting house by one John Hancock, who served as one of the city's bankers. In fact, if you ever go there to the restaurant, his safe is still there. So these are really historic buildings. The Custom House block, which is the building currently undergoing an extensive historic renovation, approximately 200 years old. There was no building department back then. There were no records kept, but that's what we think. We also think the building was longer at a point in time, went further out towards the water. And I also understand, just from having been around a bit, that this part of the city was all but abandoned in the years after World War II. The elevated train was taken down in the 40s. They used the metal for the war effort. There then was a surface train that went back and forth over cobblestones for many years. And then this council, over 50 years ago, before my time, adopted the Waterfront Urban Renewal Plan under the encouragement of the Chamber of Commerce, Frank Christian, among other people. And as a result of that, all the land, but not the buildings, were taken by the BRA. And that's the order of taking that is attached as a matter of reference. And the goal being that all the space which was not built upon should in fact be available as open space. Now, as referenced by Mr. Bronya, a federal grant was applied for and utilized to create the pavilion area at the end of Long Wharf. And the uses of what most of us would consider an extension of State Street probably have been the same for a long time, going back to a time when there were cobblestones and people would drive wagons down there with horses in order to get things off of boats, because obviously there was no service. And the Blue Line tunnels beneath the street, more or less 100 years, and we believe there's been electrical service and telephone service to these buildings back to the time of Mr. Edison and Mr. Bell. Once again, there's no permits to prove exactly when either would have occurred, and what we're asking for today is to in fact provide new service to these old buildings so it can be efficient and modern, as opposed to the systems that may have been under the ground for 100 or so years. When the concerns were raised about the activation of the pavilion with a licensed establishment, there was a court suit, and Mr. Bronya made reference to that. If he wasn't a plaintiff, he knew some of the people who were. And as a result of the decision by the Court of Appeals, I think it's fair to say the BRA does not want to imperil the ability of the agency to secure federal funds. And that's why there's an ongoing discussion between the BRA and the state, specifically Melissa Cryan, who is at EOEEA and who serves as the agent for the National Park Service here in Massachusetts. Earlier this summer, Ms. Cryan told Mr. McGinnis that it was necessary that pursuant to Article 97 of the state constitution, that in fact there be a special act of the legislature which requires a 2/3 roll call vote in order to secure the right of the utilities in question to put service beneath the street to replace the service which has been there for a long, long time. And in the legal parlance, it's called a subsurface easement because it is something below the ground. And the end result will be that there will be good new electrical service and good new cable and telephone service to these buildings. Now, Boston's been granting subsurface easements for a long time. Sitting in that chair, Mr. Chairman, I chaired the committee in either 79, 80, or 81, it all blurs after a while, that provided subsurface easements for the Devonshire and subsurface easements for 50 Milk Street. And it was done by vote of this council, didn't have to go to National Park Service, didn't have to go to the legislature, because we're talking about city sidewalks. The foundations of those buildings are beneath the public way. Many, many years later, when I was in private practice, I represented Norman Leventhal, and we secured subsurface easements for 75 State Street. And if one is ever in that garage, and truth be told, I never have been, a piece of that garage is underneath the public way. That's how they provided the maximum number of spaces and squared off the lot. And I expect, Mr. Chairman, since you've been here longer than your two colleagues, that you probably have voted on others over a period of time, because these are matters that are properly before the council. And in this case, because of the court case, it requires an additional step. And that's why we're here. Senate Council has ruled that because the land is publicly owned, that it must go through the home rule petition process. Many of these Article 97s just go straight to the State House. And the drafting of this document followed the patterns of 5 separate similar bills which have been passed pursuant to Article 97. And they really have a very simple format, that there's an identification of where the real estate is, and there's also consideration. And consideration is what Rich McGinnis referenced, that the BPDA always seeks some type of consideration for the use of that subsurface space. Ann Rogan is available if there's any questions. She manages the building. Josh Sidney is here, who can deal with engineering and technical matters. A tenant called Burning Glass has a lease to occupy the space on the 1st of October. This lease was signed a long time ago. They're taking the entire second floor. This has been for 100+ years an office building. It will be offices once again. Needless to say, no electrical service, no certificate of occupancy, tenants cannot move in. That's why this is a matter which does not admit of delay. Meanwhile, pursuant to the existing service, the Trout House remains in operation. Boston Harbor Cruises and Liberty Schooner have been there for many, many years and continue. So the council has to report this out. It has to be sent to the State House. Senator Boncory, as a courtesy, will file it in the Senate. It's already been pre-reviewed by Senate Council. They will review whatever comes from City Hall. They may do some technical tweaks, but not substantive matters. And that requires a 2/3 roll call vote of both houses. At that point, provided that the easement documents have been signed by the 3 utilities with the owner of the real estate, namely the BRA, and the plans are in place to be recorded at the registry, then the work can proceed and certificate of occupancy can be granted and tenants can move in. And trying to be objective here, because obviously my interest is that of the client, I think it's fair to say that most anybody who's lived in Boston over the last 100 years assumes they'll have electrical service. And maybe for the last 75 or so years, most people have assumed they have access to telephone service, and maybe for the last 25 years for cable and internet service. And the folks who are moving into this building need electrical service, and that's why we're here.
Very good. Just a couple of questions for me. Why is the address of the parcel not identified in the legislation? It kind of goes by the deed book. So is there an address specific to this home rule
It's had
petition?
various addresses. This is actually the public way. The public way may not have a legal address.
Okay.
That's why we identify it by the book and page. The meets and bounds are identified by the taking document from the late 60s.
Okay. And not having a horse in the race, why are there only certain utility companies mentioned and others not? Is it because they've signed up?
Those are the ones who've
Those are-
expressed interest in providing service
Gotcha.
to the site.
And are there any situations where the BRA would need to either revoke or amend this easement? Do you see any situations where that would happen?
We don't believe so. It's a standard utility kind of connector. Once it's set, it can be accessed. New lines can be put down, but it's really just setting the easement right of way. If you go out to the site, this is an extension of State Street. So State Street has 2 owners, the City of Boston, and that ends right about in front of the Marriott Long Wharf.
Atlantic Avenue, yeah. Atlantic.
And then the BPDA's portion goes starting at the Marriott Hotel towards the water's edge. So it all looks as one roadway, but the alignment of Long Wharf, the pier itself, that's within our right-of-way.
Okay. And then just drawing from the public testimony, we had some folks from the north end here would sort of like to maybe get some type of presentation at NURA, and not sure if that's something that can be done relatively quickly. Also,
Absolutely.
we heard from Comcast that had a question on Section 4, and you heard that testimony. Is there any thoughts to the testimony on Section 4 of the document?
We're happy to present this to NURA. We benefit from knowing the right-of-way. If you just look at the legislation, you don't know what is happening. You know, is this under the true park space or is it a roadway? So we're happy to do that. The project at the Custom House Block building is a pretty extensive project, but it's a renovation of existing buildings. So I don't know if it was ever put before NURA or other organizations.
It's a matter of right to renovate the building.
But, you know, a lot's happening out there, so it wouldn't hurt to have, you know, Capital Properties and us join, you know, any of that engagement, just to give them updates on the project and these easements. Happy to do that.
Good, so obviously, given that, then if, before we leave here, if you could maybe make a connection there with the
Yeah,
NURA
happy
folks,
to.
just to try
Yes.
to.
And our
get
team
on
would be happy to
expedited, yeah,
participate.
And also with Comcast and maybe Ian or some of you guys can figure out those issues. So with that, I'll turn over to my colleague, City Councilor Lydia Redwoods, who represents the district.
Thank you very much. I just want to make sure I'm clear. There's with the both of you, there's the understanding that the NPS, the National Park Service, does not need to be involved in this.
That's right.
Right.
There's no
The
legal
state-
obligation.
The state, Melissa Cryan serves as the agent for the Park Service in the Commonwealth of Massachusetts. And in fact, it was her conversation with Mr. McGinnis, late June, early July, whenever it was, Rich, that brought us to this point.
So the National Park Service was notified about this and told you, Rich, that they do not need to be involved.
We did not notify the National Park Service.
Okay.
We went through their kind of local conduit, which
Their
is
local
the
conduit.
division.
So a
of-
representative of the NPS.
Yes, yes.
They're informed and they have told you that they do not need to be a part of this.
Yes, the National Park Service protected property, you don't need any right-of-way allowances for
Mm-hmm.
subsurface. It's more of an Article 97 state constitution issue.
So I just want to
And
make sure
when,
that.
by the way, when we did construction above ground, again, this is a historic renovation of a 200-year-old building, we had extensive documents with the Park Service for the utilization of space above ground, but they've never had any involvement with anything below ground.
Okay.
And just on that point, if they would be willing to reduce to writing something to that effect, or even if it's in an email form through the chair, I'd like to just have something for our records on that.
That they do not need to be involved.
That's what we were told by the state, yes.
National Park Service approved this.
Yeah,
We have documentation.
Yeah, Josh, can you
Great.
just speak for the
Yes.
record? Mr. Sidney is our engineer. He does all the
Excellent.
technical stuff. I went to Latin school,
So
so.
Josh, if you just state your name and affiliation for the record.
Josh Wissany, I'm representing the owner, Capital Properties. We have documentation from the Park Service approving this work, so we can share that with this committee.
Excellent.
So,
Thank you.
Good. All right,
I
that
have
would
a
be,
copy
that's,
here for you guys.
yeah, that'd be very helpful,
Yeah.
and we can have staff just make photocopies for my colleagues, so, sorry, thank you.
No, just continuing on then. So when we got the home rule petition, it references plans to be attached. Do you have the plans?
We do not have the plans at this time. We have sketches, which I would argue are insufficient for recording at the registry, and we've asked each of the utilities to get us a Mylar plan, which we expect will be in hand well before we are ready to record.
But, okay, so you do not have plans. And I appreciate the historical background and explaining how the process has changed, and also explaining how, due to the lawsuit, a different hurdle or a different step has also been added. I might also add to that conversation that consistently, at least throughout the neighborhoods that I represent, the process also involves, a lot of back and forth with the community, and well in advance notice of understanding what's going on. Because, I mean, on its face and the way you described it, it strikes me as just updating electrical things, a very simple thing. But it seems like we got to the end result before we got through the process, right? And I would have loved to have seen that simple conversation and the way you eloquently describe what's going on presented to both New Nick and Nura, just to at least inform the community. I'm informed by my community about their thoughts on things. I also understand that as the owner of the property, the BPDA, BRA will be compensated for this use of this easement. But part of the conversation is also how the community itself receives some form of mitigation or receive some form of benefits as well. That, is a conversation that's open, that's transparent, and that's a back and forth. So I understand the pressing need due to the leases that are signed, but I don't see how this can get passed through this house and both houses and certificate of occupancy by October 1st. So seeing as that there might be a delay anyway, it looks like there might be time to allow for that community process, and then for the folks to come back here for us to really get it out of this house so it can get it moving on in the other houses. And that's something I would prefer.
Yeah, respectfully, Counselor, this is a matter which is more urgent than most that come before you. Until June or July, I forget the exact date, nobody had told the owner of the property that these steps were necessary, and we've been back and forth between the State House and City Hall ever since. I think that Mr. McGinnis had stated that they're prepared to make a presentation to the two separate neighborhood groups, and our team could certainly go along. We would hope it could get through the council and get up to the legislature, where we'll take a number of weeks for discussion by both houses there. Again, they're not in session that often, so it's rare to get a roll call. We certainly can get the meetings in before then. We would hope the council could send it up there, and certainly Representative Michael Witz and Senator Boncory listen to the same constituents as the folks in this building do.
Larry, can I add something to that? Joshua Sidney again. The City of Boston implements a moratorium of excavation of public streets starting November 15th. So if we don't have the ability to implement this new electrical service before then, we'll most likely be cut off until April 15th of next year. So we don't have a problem with meeting with the community, but if we let that process play itself out, we might be cut off, which the building wouldn't get a new permanent service.
You're talking the street closures once the weather changes?
Yeah,
correct?
November 15th, so we're not that far away from that.
Yeah, the community groups meet once a month, so you may even meet possibly Octobers or, I don't know, Septembers, and you can get on the agenda and make the presentation. So I'm not hearing an inability to go through the process. I understand the pressingness of the November 15th deadline, but I think we're all saying the same thing. And so the community groups are both here represented by folks. New Nick is behind you, and you have Nura over here. You can get on their agendas, present before them, hopefully with the plans. And I think that that's going to be something that is an issue if you're presenting with no plans. You should have that, your letter from the MPS, and just go out there and talk directly to folks. And I think it's as for many folks, it's just a matter of respect and understanding of what's happening, informing them, and then moving on.
So Eversource needs about 8 weeks to put in this new dock bank in the street. So we're going to be beyond the moratorium if we wait a month to meet with these community groups. If we could expedite those meetings or have them moved up or a special meeting or something like that, we're going to be into the moratorium.
And I don't know, you said Eversource is that impacting the plans? Being able, I didn't hear.
We don't have the ability to occupy the building without a new service.
Oh, yeah.
So
no certificate of occupancy until the
Correct.
services.
right. So
So let's see.
we're in a tough spot.
So just if I may, just the folks from Nura and New Nick, when is your next meeting?
The second Thursday of the month is...
Second Thursday is Nura and New Nick is?
We can, respectfully, we have no problem meeting with both community groups, but we can't wait that long.
Do either of those organizations have the ability through executive session or through an expedited or emergency meeting, given the situation that we're hearing about now with respect to certificate of occupancy and the street potentially closing for utility services? That's something that would move the executive boards to maybe call for some type of executive or special session? Just trying to play this out. Nunick is yes, and Nura is?
You might want to go to the microphone.
Okay. So Nura has concerns around their rules and policies and procedures, so, okay. Great.
Because also we need these easements approved and get the conduits group schedule from all the utility companies. And as you know, these things don't happen overnight. And I'm very, very concerned that if we don't expedite this community outreach, the building isn't going to be able to beneficially occupy the building.
But I think what I wanted to, where my confusion is even if these were expedited and you had your meetings and they got through this house, do you have a guarantee it's going to get through the State House by November? I mean, that's an issue that you would have, period, even if we're moving fast. I don't know that either of my colleagues in my delegation, my rep, Michaelwitz, or Senator Boncory would be able to get it through both houses this fast. I mean, they have thousands, if not hundreds, definitely hundreds of bills right now. And I understand the urgency that you feel about this particular issue and this particular home rule, but there's a lot of other things in line that are equally urgent that impact the entire state. So I'm questioning honestly that you could get through both chambers of the State House in what, 3 weeks?
From my conversations with Senator staff and the representative staff, as soon as the bill is up there, they'll get moving on it quickly. They are aware of the time constraints involved. And they are in session, you know, in the even-numbered years, they're out of session 31st. They are back in session now. They're having formals once, sometimes twice a week up there. But it has to be sent up there before they can deal with it.
So meaning being a smaller issue for them, they would expedite it? Those
That's what they
conversations
told
have
me.
happened?
Yes.
Do we have, tenants have been signed up, leases signed, is that stuff?
Yeah, and, you know, there's penalties and there's deadlines. And right now, we don't have the power to accommodate a full tenant moving into the building. It's a major issue for our client. And it has nothing to do with them. They're tied up with a lawsuit between the city and the federal government about who owns the property. They're just dragged into it, unfortunately. We're trying to do the best we can with the situation, but to the extent we can expedite whatever community involvement we have to do, whatever drawings we have to show, we're happy to do that. But it's a very large hardship for the building owner.
And one that none of us were aware of until a few weeks ago.
And what's the scope of the job? So you need to trench all the way down the road to the
there's,
chart house?
So from Old Atlantic, which is basically right at that intersection that Rich mentioned previously, which is directly adjacent to the Marriott, and it's about 300 feet.
At the front side of the Marriott? So like right at the train station, or on the back side?
The backside, we're like legal
Tiers.
seafood. We're like legal seafood, and Marriott is
yeah.
The street's called Old Atlantic Wharf, not the State Street intersection, and it's a straight shot from there down to the building, and then turns into the Custom House block. It's about 300 feet of a duck bank, and there's manholes there now, and there's services there now. They're just not large enough to accommodate a 21st century renovated office building. And there's, as Rich mentioned previously, there's water mains, sewer mains, existing data infrastructure already in place. That street is a hornet's nest of subsurface easements already.
But if you get in the ground before November 15th, you can extend it out, correct?
It really all depends on the DPW and the Parks Department in the city. Typically, they don't like doing that. It would have to be a conversation with them to say, is there a leniency to do this during the winter? But at that point, if it lasts that long, our client's in a very difficult position. They can't perform on what they promised.
And the tenancy is supposed to begin when?
The beginning of next month. So we've been dealing with this for years with the Executive Office of Environmental Affairs and the Park Service, because this is a historic tax project. And we got approvals, which I just gave your staff from 2 years ago, saying this all can be approved. We have a plan showing all the new utilities. We showed scaffolding around the building. We thought we were good. It wasn't for a lack of planning on our part. The state liaison to the Park Service mentioned to the BPDA that we have to get this special state legislation approved. I mean, all the paperwork is there. And we were as surprised as anyone that we were required to do this. I mean, the owner of the building went through great stakes to accommodate for not having a transformer outside, whether it's on a pad-mounted transformer or a transformer enclosure, and finally they just gave up and said, well, we'll put it in the building. The owner has been jockeyed around significantly because of this issue. And now we're afraid that we won't be able to occupy the building.
And what's the square footage of the building?
About 80,000 square feet.
80, 80?
Yeah.
80,000. How many units or employees or tenants, or how many folks are we talking about that would be?
For count per floor, it depends if it was subdivided or not, but right now there's 3 existing tenants on the first floor. One is a Petition for the Chart House, one is Boston Harbor Cruises, and one is Liberty Tall Ships that are all Chapter 91 marine-based tenants, which is very important to our client and to the city, obviously. And then the occupant count per floor, I don't know off the top of my head. I can get that to you.
It'll be in the many hundreds. Could be 200, 300 people working there, aside from people already working there.
We have no problem doing community outreach, community involvement. We just thought a subsurface easement would be sort of fait accompli based on prior precedents. But if these community groups can meet with us sooner, we're happy to do it. And then obviously, Lydia, we can't control when the state sort of votes on this and all that stuff. But if we can control meeting sooner to expedite all this, that'd be very much appreciated.
I mean, I think the outreach is on you. You have one group that's willing to meet with you. I would meet with him today. I'm sorry, I don't know, sorry. Brent, I would meet with Brent today and see if he'll have a special meeting and you invite the members over here. I mean, that's on you to do the outreach. Brent today, and can we get a meeting together this week, next week? And so that would be my suggestion.
Duly noted.
Does it need to be, council, would it need to be a, like a sanctioned, both civic meetings have their own? Could you do one through one group and invite the rest of them? Would you be comfortable with that?
At this particular point, if NURA's comfortable with that and they're willing to do that, then I can respect that. But it is, they do put, I want you to know, NURA doesn't set up this thing to be an inconvenience to folks. They've been meeting regularly, they have pre-meetings, they come in, and they do a lot of work to make sure that they can move projects as efficiently as possible. They're all volunteers. So, to ask and move and have folks come in addition for a project is also, a special favor to ask of them as well. So I wanted to acknowledge that this is not an intent to be in the way. It's literally how all the projects are done in the North End, at least the parts that I represent, is that folks go before both of the community meetings with plans, answer all questions, and then I get a response from the community meeting, from the organization saying, no problem, we have the following problems, we don't support. And so that's the process that also you're entering into by virtue of being and developing in this community. And so I want to respect that process, and I will allow for them to change that process as they need to. But they have bylaws they need to comply with as well. So I just wanted to acknowledge that no one wants to be an inconvenience, but this is the process at hand. And yes, please talk with Brent afterwards about getting at least to New Nick.
Okay.
Mary, do you have something to add? Welcome back.
Yeah, I'd just like to point out that I'm not an officer of NURA, and I'm not here in that capacity. I'm here as a private citizen who was involved with Long Wharf over many years. Victor is the chair of our ZLC. He can certainly get this before that committee very quickly, but again, we can't speak for the organization. Had we known that that would be the request, we could have tried to get some officers here to see what they would say. But I would just like to, correct a few things just to clarify that. There is no, the gentleman has mentioned they're tied up in litigation between the city and the feds. There's no litigation. I mean, that's long since over, long since known. As Attorney DeCara has pointed out, he's been working on this over the summer, working with the state representative, which is actually not the National Park Service, but a local representative who doesn't necessarily speak for the NPS, but working with them, working with Senate Council. And I guess I have to ask, why was no one working with the neighborhoods? They certainly knew we existed. They knew we were there. They knew our process. We could have dealt with this. We would have happily dealt with this. This is what we deal with. So I'm just can't help but feel that there's a little bit of brinksmanship going on here. And I think, as Councilor Edwards has pointed out, yes, certain people within the legislature may have indicated that they'll expedite certain things, but whether that will happen within the very tight time frame, especially finding out that there aren't even any plans for anyone to look at, it's just a little concerning. I just kind of feel like something is kind of being pushed through that maybe is fine and maybe it's not. I just don't know. So thank you.
Any follow-up response to that, any gentlemen? The litigation stuff?
The litigation's resolved by the
Right.
Court of Appeals. It's behind us.
I think the only reason why we mentioned the litigation piece is that typically the Park Service wouldn't be involved in putting in a new electric service to the building. That was sort of my previous thought. We're not trying to, this isn't gamesmanship, we're trying to do the right thing. I honestly didn't think that we had to reach out to community groups to install a below-grade electrical service. If that's my fault, and I apologize.
Very good, thank you. Anyone else here wishing to offer public testimony? May do so now, if never hold your peace. Seeing and hearing no additional desire for public testimony, that closes the public testimony. Any of my colleagues have any comments, final thoughts? So, I mean, it's clear that there's enough here. We kind of get the sort of the urgency of the situation. Our hope is that before folks leave this chamber here, they can have some conversations with a couple of the community groups to see if we can try to resolve at least the community process piece of it, before the council takes formal action. Obviously, we don't want to see tenants and other folks dislocated and litigation ensuing and all that stuff. So I see the picture clearly, as do my colleagues, just trying to make some sense as to how we kind of missed that community piece, but hopefully that can be resolved among the parties today before they leave. So with that, if there's no additional testimony with respect to docket 1264, message and order approving a home rule petition to the general court entitled an act authorizing the Boston Redevelopment Authority to grant easements for utility purposes over a portion of a certain parcel of land located in the city of Boston, that was sponsored by Mayor Martin J. Walsh. The Committee on Government Operations is adjourned. Thank you.